is happy to announce that we have book stalls at the venue featuring titles by all the authors speaking at PLF 2024. Books by Sri Aurobindo Ashram are specially featured. The festival also features an independent stall by Anadi Foundation for the great work they are doing in education, well-being, sustainability, culture and heritage, and an independent stall by Go Force promoting nationalism through merchandising and gifting. The Pondy Lit Fest would like to thank our platinum partner Motwani Jadeja Foundation, our gold partners, platinum digital partner Asianet News Network, our gold partners Mahendra Next Wealth and Embassy, our session and beverage partner Radico, our session partners Zoho and Jan Ki Baat, and our travel partner V-Trip. Stay connected with the latest updates and highlights of PLF. Follow us on Twitter at Pondy Lit Fest, on Insta and FB at PLF_Pondy Lit Fest. Do subscribe to our YouTube channel at Pondy Lit Fest for insightful videos and event coverage, and share pictures using the hashtag PLF 2024. I also want to announce that we have a special session this evening with Shivarur and Anand Ranganathan. It is about sacrilege through secularism, the case of the Tirupati Laddu, Shivarur and Anand Ranganathan in conversation, 7:30 p.m. to 8:15. This is a new session added today. But right now, the opening session of the afternoon is a lecture by Advocate Vishnu Jain, lawyer, advocate on record, Supreme Court of India, on reclaiming sacred spaces, legal challenges.
धर्म संस्थापना के देवता भगवान श्री कृष्ण के चरणों में मेरा नमन, परात्पर गुरु डॉक्टर जयंत बालाजी आठवाले के चरणों में मेरा नमन. And a very good evening to all of you, and I'm really thankful, a very good afternoon to all of you, and I'm really thankful to Pondicherry Literature Festival for giving me this opportunity to come down here again. And actually I feel that whenever I come down here, what is expected from me by ALO is to give a report card of the entire year as to what is the progress which was done last year and now what's the progress. So last year, as we all know, I had given a presentation so far as our case of Kashi is concerned, and so far as our case of Krishna Janmabhoomi is concerned. So I'll be sharing with you the progress which our civilization has had in this 1 year, and as of now where we stand in these two cases. And apart from that, I'll also be discussing with all of you about the Bhojshala case, the Bija Mandal case in Madhya Pradesh, and other civilizational issues which are very, very fundamental and which actually need attention for our community as a whole. So starting with the progress in Gyanvapi Kashi Vishnath case, as you all remember that in Gyanvapi, a very significant development has happened. And the development is that we were continuously asking for an ASI survey in the Gyanvapi premises, the alleged Gyanvapi mosque, though there is no such word as Gyanvapi mosque in Islam, but the word Gyanvapi mosque is used. So there was an ASI survey which was conducted in the so-called disputed site. And after a survey exercise being conducted for around 92 days, the Archaeological Survey of India submitted a report before the District Court of Varanasi on 25th of January 2024. And let me tell you that this survey which has been conducted and the report which has been submitted before the District Court of Varanasi excludes the Vazu tank area. So as of now, the Vazu tank area where Shivlingam was found on 16th of May 2022, that area is excluded from the purview of this present survey. I'll go in a bit so far as that aspect is concerned. So when this entire survey exercise was conducted, lot of important evidences have been found in this survey. A very crucial aspect is that during this survey, it was, you would have heard on various mainstream medias and TV channels that it was one of the front line of defense of Anjuman Intizamiya and various Islamic scholars that Gyanvapi mosque precedes the period of Aurangzeb. So during this survey, we had found a stone inscription which was broken into half piece, and the original picture of that stone inscription is with the ASI, and that original picture is also a part of this survey report. In that stone inscription, it is specifically mentioned that this so-called mosque was during the period of Aurangzeb, and how a pre-existing temple was demolished to give it a shape of mosque. All those evidences have also come in light in this ASI survey. Apart from that, the ASI has found in the so-called alleged Gyanvapi mosque various inscriptions written in various languages, Kannada, Tamil and other languages, which actually revere Lord Shiva, which actually are written by the devotees and the which are originally a part of the structure. There are various artifacts. 18 number of artifacts have been found in this ASI survey, which prove to hilt that this was the premise, this was the place of original Adi Visheshwar. The ASI has given a categorical finding that beneath the so-called structure, a huge structure, a pre-existing structure of Hindu temple is existing. The ASI has also given a finding that the existing structure, which is the disputed structure, is not a mosque. It is not having any characteristics of a mosque. So far as this controversy is concerned, that whether Gyanvapi mosque is a mosque or not, I think after reading the report of the ASI, this doubt can be cleared from the minds of all of us, because ASI is an expert body, and by virtue of section 45 of the Indian Evidence Act, it has an opinion of, it has a value of an expert opinion, and the experts have given an opinion that Gyanvapi mosque was existing on a pre-existing Hindu structure, and all the artifacts and all the evidences which have been found during the survey have been videographed, have been recorded by the ASI, and the report of the ASI was submitted before the Honorable Court on 25th of January 2024. Now there was an effort by Anjuman Intizamiya that when this ASI report was submitted, their entire planning was that this report should not be brought in the public domain. So it's my duty as a lawyer, because let me tell you that like in Ram Mandir case, all of us who are sitting here may not be parties to Ram Mandir case, but the judgment which was delivered by the Honorable Supreme Court as well as Honorable Allahabad High Court in Ram Mandir case is binding on all of us, because it was on the principle of Order 1 Rule 8. When the case is made as a case of Order 1 Rule 8, which means a representative suit, the legal principle is that even though the communities, each and every individual of a community is not a party to the case, but whatever is the final verdict in that litigation, it is binding on both the communities. So that's why from that logic and from that perspective, Gyanvapi's case, Kashi Vishnath case, it's not just a case of Vishnu Shankar Jain or Hari Shankar Jain. This is a case of the entire community, and it was my duty to bring before the community what the ASI has said. And therefore, the moment the ASI report came, I read out the ASI report before all of you, and the ASI has given an important survey and opinion and expert evidence so far as the disputed area is concerned. Now coming to the other aspect as to what is remaining in Gyanvapi is a very, very crucial aspect. As you all know that survey exercise of Advocate Commissioner was carried out in Gyanvapi on 6th and 7th of May 2022 and 14th, 15th and 16th May 2022. On 16th May 2022, on the first floor of the so-called mosque, in the Wazu tank, we had found Shivlingam, And we believe, and I strongly believe, and I want to reiterate it before all of you, that that Shivlingam is existing on the first floor, and it is going a lot deeper. And by no stretch of imagination, what we found on 16th May 2022 is a fountain. It's only a Shivlingam, Shivlingam and Shivlingam. Now, it's not that we just claimed it, that it's a Shivlingam and we kept mum. We immediately filed an application under Order 26, Rule 10A of the CPC before the District Court of Varanasi, and we asked that this area must be surveyed by the Archaeological Survey of India, and an expert report, an expert opinion must be given that whether it's a Shivlingam or a fountain. The Honorable District Court of Varanasi had rejected our application on the ground that the Supreme Court has sealed these premises, therefore we cannot direct the ASI to enter into this sealed area. Though our interpretation was completely different, the Supreme Court on 20th of May 2022 had mentioned in its order that the district judge is at liberty to decide all the applications which are filed in this suit. So we challenged this order of the Honorable District Court of Varanasi before the Allahabad High Court, and Honorable Allahabad High Court, after hearing both the parties, on 23rd of May 2023, on 12th of May 2023, had given a historical verdict, and the Honorable Allahabad High Court, after taking an affidavit from the ASI, which was running into 54 pages, where the ASI had also said that we can do this survey exercise of the Shivlingam area, of the Vazu tank area, without even damaging it, had directed on 12th of May 2023 to conduct this survey by the Archaeological Survey of India. Now, the irony is that Anjuman Intizamiya, which was saying that it is not a Shivlingam, it's a fountain, and they were so much ready with they were having so much of conviction in their argument, you will be surprised to know that the Anjuman Intizamiya approached the Honorable Supreme Court on 19th of May 2023, which was the last working day of the Supreme Court. After that, the Supreme Court was closing for summer vacations. And on 19th of May 2023, the Honorable Supreme Court stayed the order of the Honorable Allahabad High Court, which directed ASI survey in the Vazu tank area. So as of now, in Gyanvapi case, what remains is a very, very important and crucial piece of exercise, that we need to have this survey conducted in this sealed area. And for that, we have moved applications, and we are trying from past 1 year. We have moved application for vacation of the interim order. We have sought the Honorable Supreme Court to hear this matter. But as of now, we are not successful. But I hope in future, our voices will also be heard. And someday will come that when survey will be conducted in this sealed premises, and it will be proved to hilt that what we found on 16th May 2022 was a Shivlingam and was not a fountain. So that is one aspect of this entire case, Gyanvapi case. And after the ASI submitted a report, one very important development has happened, and I feel, and whatever I am narrating before you, I am really sorry, whatever I am narrating, please don't find that there is any emotion of what we have done. The emotion is, the idea is to tell you that what we can do as a community. And Gyanvapi case is a classic example that what we can do as a community. And for that, I wanted to cite this very important development which has happened in this case. Let me tell you that during this entire ASI survey of 90 days which was conducted, a very shocking incident happened. Despite the orders of the Supreme Court and the Allahabad High Court, which directed the 4 women plaintiffs to participate in the ASI survey, those who argue that in Sabrimala women must enter, despite the orders of the highest court, 4 women plaintiffs were not allowed to enter the mosque during this survey exercise. And it so happened that right in front of Nandi, the Nandi which is situated in the present temple, there is Vyas Tana, which is on the ground floor of the so-called alleged mosque. in this Vyas Khana from time immemorial, and approximately from past 600 years, the Vyas family, through succession, through hereditary pujariship, through hereditary shivaiship, was worshipping in the premises in question. And it so happened that in violation of the Places of Worship Act 1991, the Vyas family was thrown out from that Vyas Khana by the Mulayam Singh Yadav government in November-December 1992-1993, and the puja which was conducted by the Vyas family was stopped. And at that Khana, there were 2 locks which were put. One key was with the Vyas family and the other key was with the district magistrate. Now this entire premises, if you would have seen on the mainstream media, is barricaded by iron fencing. So when we went for this ASI survey, we found that this gate of this Khana has been broken. There is no gate in this Khana. And when one of our senior counsels from the Supreme Court, a lady senior counsel from the Supreme Court entered that Vyas Khana, she was told that you cannot enter this Khana because this is part of the mosque premises. So we understood during the ASI survey itself that a very deep-rooted conspiracy is going on to capture this Vyas Khana. They were claiming that Vyas Khana, and all the efforts were going on to take illegal possession of this Vyas Khana. With this perspective, we filed a civil suit on behalf of the Vyas family in the District Court of Varanasi. The Honorable District Court of Varanasi heard the matter, and a very historical chain of events have happened. The Honorable District Court of Varanasi on 17th of January 2024 directed the receiver, which is the District Magistrate of Varanasi, to take over the possession of this Vyas Khana. And in compliance of the orders of the Honorable District Court of Varanasi on 24th of January 2024, the District Magistrate of Varanasi had taken over the possession of that Khana. Then we had a second prayer in our application, and the second prayer was that in the Vyas Khana, through rituals and through time immemorial, Niyamit Puja, Ramayana Path and Rudra Abhishek and all these puja parts were going on, which were stalled in December 1992-1993. So that puja part must start. And after hearing both the parties, the Honorable District Judge of Varanasi on 31st of January 2024 directed that puja part must immediately start, and within 6 hours, the Uttar Pradesh government, the receiver, in compliance of the orders of the District Court of Varanasi, started the puja part in the Vyas Khana, and from that day till today, the puja part in that Vyas Khana is going on. So now I put a question to myself, that on the ground floor of the so-called mosque, if puja part is going on, and if we read the report of the ASI, what is the religious character of the Gyanvapi mosque? The religious character was of a Hindu temple. It is the original seat of Lord Adi Visheshwar, and till today it is having all the characteristics of a Hindu temple, of the original seat of Adi Visheshwar. So by no stretch of imagination, it's a mosque, and the persons who are entering there and offering namaz is in total violation of our Sanatan Hindu principles. So the next step is that we are proceeding in the trial of the suit, and I must very frankly admit in front of all of you that after this order, which was passed by the Honorable District Judge of Varanasi on 31st of January 2024, there has not been much progress in the suit. For the reason that for 3 months, because the Honorable District Judge of Varanasi retired on 31st of January 2024 after passing this order, and from that time for next 3-4 months there was no appointment of District Judge of Varanasi. Let me tell you that there was a mandate given in this very case by the Honorable Supreme Court that this case has to be tried by the District Judge of Varanasi. But for 3 to 4 months, there was no appointment in the district of Varanasi of the district judge. And then in June, the courts had closed for summer break, summer holidays. And from July onward, this case is posted mostly on every Saturday. And whenever we travel to the district court of Varanasi on Saturdays, there is either a condolence or a strike, and the matter is not being heard before the Honorable District Court of Varanasi. So, as a lawyer, the situation in front of us is that our matter, which I believe is a very core civilizational issue, is not being heard from past 9 months. There is no progress in the case from past 9 months, despite so much of efforts before the District Court of Varanasi. And I have filed an application before the Honorable Supreme Court, and the demand is, the prayer is, that all these matters pertaining to Gyanvapi must be transferred to the Allahabad High Court before 3-judge bench of the Allahabad High Court for original trial, like it was done in Ram Mandir case, because this is a case which goes to the core of our sentiments. This is a case because out of 12 Jyotirlings, let me tell you, 5 Jyotirlings are Swayambhu, and out of those 5 Swayambhu Jyotirlings, the very first Jyotirling is of Adi Vishweshwar, situated in Kashi. So this is a case which goes to our mother of civilization, which is the cradle of civilization. And for this case, so many constitutional and important issues are arising that it must be transferred to the Honorable Allahabad High Court in exercise of powers under Section 24 of the CPC. Because in Uttar Pradesh, unlike other states, if you have to file any civil suit, it has to go before Civil Judge Senior Division, then it goes before the District Court, then it goes before the High Court, and then the Supreme Court. So 4-tiered system is there. Unlike other states, if you have a commercial dispute, you can directly file a civil suit before the High Court. So there is such a legal concept in Uttar Pradesh that you have to file a civil suit before the Civil Judge Senior Division. So we have cut down one layer when the Supreme Court transferred this matter to the District Judge Varanasi, and now we are asking for getting our suit transferred to the Honorable Allahabad High Court. And I am hopeful that in the near future the Honorable Supreme Court, considering the prayers which have been made and considering the sensitivities which are involved in the matter, will examine this issue, that whether this Kashi Vishwanath case must be transferred to the Honorable Allahabad High Court for original trial, just like in Ram Mandir case it was done. So that is the progress, that is the scope where our Kashi Vishwanath case is existing as of now. Now moving forward, in Krishna Janmabhoomi case, certain very important developments have happened. Because there is paucity of time, so I am not going into the historical background of Krishna Janmabhoomi case, because I had explained it on this very platform on the last occasion. So a very important development has happened in Krishna Janmabhoomi case, that the Honorable, when this matter in Krishna Janmabhoomi case, let me tell you that overall 15 civil suits were filed before the Civil Court of Mathura, and this issue was arising that it was very difficult for the matter to be adjudicated and decided before the Honorable Civil Court of Mathura. So we made a prayer and a request before the Honorable Allahabad High Court, and the request was that just like Ram Mandir case, Krishna Janmabhoomi case must also be transferred to the Honorable Allahabad High Court for original trial. And on 26th of May 2023, all the civil suits pertaining to Krishna Janmabhoomi case, accepting my prayer, were transferred to the Allahabad High Court for original trial. The trial started before the Honorable Allahabad High Court from 18th of October 2023, and immediately we moved an application before the Honorable Allahabad High Court for survey of Shahi Idgah Masjid by Advocate Commissioner. Our prayer of survey of Shahi Idgah Masjid by Advocate Commissioner was allowed by the Honorable Allahabad High Court, and when this order was challenged before the Honorable Supreme Court, the Honorable Supreme Court stayed the order of survey passed by the Honorable Allahabad High Court. So as of now in Krishna Janmabhoomi case, so far as this survey exercise is concerned, because we have very categorically mentioned in our application that this Shahi Idgah mosque is no mosque in the eyes of law, and the Karagar of Kans, where Lord Krishna was born, is still existing there. There are a lot of idols of Hindu deities which are existing on the spot. The structure itself has all the signs and symbols of Hindu temple, but this order was stayed by the Honorable Supreme Court, and the matter is being listed before the Honorable Supreme Court on 5th of November 2024 this year. So we are hopeful that we will be able to convince the Honorable Supreme Court to vacate this interim order, and this survey of Advocate Commissioner, which is a non-invasive survey, must be conducted in the premises in question. Now, when this entire issue was stayed before the Honorable Supreme Court, it's not that we just kept silent. An application was filed by Shahi Idgah Masjid, and the argument by Shahi Idgah Masjid in Krishna Janmabhoomi case was that this case does not deserve merit. This case must be nipped in the bud. It must be dismissed at the threshold, and by virtue of powers enshrined under Order 7 Rule 11, this case must be dismissed, and 5 laws were quoted by Shahi Idgah Masjid before the Honorable Allahabad High Court, and those 5 laws were that their argument was that this suit is barred by the Places of Worship Act 1991, this suit is barred by the Waqf Act 1995, this suit is barred by the Specific Relief Act 1963, this suit is barred by the Limitation Act 1963, and this suit is barred by Order 23 Rule 3 of the CPC. Now let me explain it to you in very simple term. Their argument was that Places of Worship Act has a mandate that what is existing on 15th August 1947 must exist as it is, and there cannot be any suit or lawsuits which can be filed for restoration. Their second argument was that Shahi Idgah Masjid is a Waqf property, and therefore this entire matter must be transferred to the Waqf tribunal, and it cannot be adjudicated by the Allahabad High Court. Their third argument was that there has been no relief of possession by the devotees of the Shahi Idgah Masjid, where we believe the asthan of the deity is. So therefore this suit is barred by the provisions of Specific Relief Act. Their fourth argument was that since there is a lot of delay in filing this suit, because their argument was that this suit is barred by Limitation Act, we have not come within the period of 3 years before the Honorable Court, therefore this suit is barred by Limitation Act. And last argument was that since there is already a compromise which has happened on 12th of October 1968, therefore this suit is barred by the provisions of Order 23 Rule 3A of the CPC. I must very strongly, the matter was heard before the Honorable Allahabad High Court in Krishna Janmabhoomi case from February till the month of June 2024 for 4 months, and after detailed hearing, the Honorable Allahabad High Court has given a historical verdict whereon all those 5 accounts which I have cited just in front of you, their application under Order 7 Rule 11 has been rejected, and the Honorable Allahabad High Court has held that this suit is not barred by the Places of Worship Act for a simple argument. And this is a very important development in Krishna Janmabhoomi case. We have found out a notification of the Archaeological Survey of India of 25th of November 1920, wherein the ASI has declared this so-called disputed structure Shahi Idgah Mosque as a protected monument. And very interesting thing is that in that notification of the ASI, and this is ASI not of today's era, this is ASI of 25th of November 1920, the ASI records in the order that there was a pre-existing temple, that temple was destroyed, and the site is used as Shahi Idgah Mosque. So far as the question of demolishing a temple is concerned, it is already proved by the orders of the ASI on 25th of November 1920. And the legal position which emerges is this, that when any monument is declared as a protected monument under section 4 subclause 3 of the Places of Worship Act, it is exempted from the purview of Places of Worship Act itself. So the moment Shahi Idgah Masjid came up with this argument that this suit is barred by the provisions of Places of Worship Act. Section 4 subclause 3 of the Act itself says that if any monument is a protected monument, the Places of Worship Act will not apply. So, I am not exaggerating, but the fact is, to this argument, Shahi Idgah Masjid had no submissions before the Honorable Court. So far as the second aspect is concerned, which was a very controversial debate which happened before the Honorable Allahabad High Court as to the attraction of the provisions of Waqf Act in this case, they filed a notification of February 1994 saying that this mosque has been declared as Waqf property, so we have to go before the Waqf tribunal. So to meet that argument, to counter that argument, we had cited two judgments of the Honorable Supreme Court, which one is Ramesh Govindram's case in 1979 and the other is Fatima Begum's judgment in 2010. And in both these judgments, the Honorable Supreme Court has held that if a notification is issued under the Waqf Act 1995, it will not apply to non-Muslims. So assuming, though not admitting, that there was a notification declaring Shahi Idgah Mosque as Waqf property, that notification was not binding on us. And the third limb of submission was that this Shahi Idgah Mosque itself, we are disputing that it's not a Waqf. And let me also tell you that entry which they had highlighted before the Honorable Court is also a very doubtful entry. So we had argued before the Honorable High Court that the Honorable High Court has jurisdiction to decide this case and this suit is not barred by the provisions of Waqf Act 1995. And on that account also we had won before the Honorable Allahabad High Court. So far as the third aspect is concerned, there was a specific pleading in our suit where we had asked for possession of Shahi Idgah Mosque. Can you imagine that we will file a case on behalf of the community and we will not ask for possession? Their argument was that we have not asked for possession of the Shahi Idgah Mosque. We had asked for possession, that prayer was there in our suit, and despite prayer being there in our suit, they are saying that no possession has been asked. So on that account also their argument was rejected by the Honorable Allahabad High Court. And so far as the provisions of Order 23-3A is concerned, the Honorable Allahabad High Court has held that it is not applicable in this case because the devotees were not party to the original compromise of 12th of October 1968. And so far as the limitation is concerned, it's a mixed question of law and fact. So far as that aspect is concerned, the civil suit can go on. Now this detailed judgment of 150 pages was challenged by Shahi Idgah Masjid before the Honorable Supreme Court. The matter was heard very recently and now the case has been posted before the Honorable Supreme Court on 4th of November 2024. So far as Krishna Janmabhoomi case is concerned, this is the progress which I wanted to narrate before you as a report card. And apart from that, there has been a lot of development in Bhojshala case, which is the place and site of Ma Vagdevi in Bhojshala, which is in Dhar, Madhya Pradesh. The ASI has given a report after survey of 98 days and a very clinching report has been given that this is the Asthan of Ma Saraswati, Ma Vagdevi, and there was a pre-existing temple. That proceedings before the Indore High Court of the Madhya Pradesh has been stayed by the Honorable Supreme Court and the matter is pending adjudication before the Honorable Supreme Court. So that is the aspect of Bhojshala case. Now there is something very, very important which I want to highlight in front of you. Because my topic is to protect the sacred spaces. But there is a very important need which has arisen, which we all have actually ignored. And the need is that we are protecting our sacred sites. We are protecting our sacred spaces. But there are certain documents which I have found, which I want to highlight before you today, where our gods, where our Lord Krishna has been most derogatory words which can be used under a judicial pronouncement against our God has been done. And if you would have heard recently, a movie had come up on Netflix, which was on top in Netflix, which was called as Maharaj. It is still there on Netflix. So the background of the movie, I'll come to that movie a little later. But the aspect is, I just assume that how many of you would have seen that movie who are sitting here? Some of you. So this movie which has come on Netflix, Maharaj, it is the most, if I can use the strongest language, completely egregious, and this movie has not depicted the correct facts. Now what has happened? There was an article which was written by Kanchan Das in 1861, and that article had actually abused, because of paucity of time I am not reading that article here, but the gist is that that article had actually not quoted and had interpolated with our original Shastras, and that article was that there is a parampara, there is a practice, there is a tradition which is going on in Vallabhacharya Sampradaya, that whatever is of a man, he has to offer to the Gurujan. And it was so written that in Vallabhacharya Sampradaya that there is a practice that you have to offer your women to the Vallabhacharyas. This article was challenged by the Maharaj before the Supreme Court of Bombay in 1962. So virtually the scope of adjudication before the Supreme Court of Bombay in 1862 was to decide that whether this article which has been published by Kanchan Das is a libelous article or not. But I cannot narrate those words which the Honorable Supreme Court of Bombay has used in 1862. And our God, Srinath Ji, we are fighting for Krishna Janmabhoomi case, but our God, our deity Srinath Ji, who is situated in Nathdwara, was termed by the Honorable Supreme Court of Bombay as an Epicurean God. The devotees who are worshipping Lord Krishna were called names in the judgment. Maharaj libel case, and I'll share that judgment with the organizers. You all can have a look at it. Page number 213, 214, 15, 16, 18 goes on to call the devotees involved in group sex, orgy, Lord Krishna as a Epicurean God, and all the Maharaj, the Vallabhacharya sect, entire sect itself dipped into sex and Epicureanism. This kind of judicial pronouncement has been passed in Maharaj libel case in 1862. And now kindly see the fact of the matter. The fact of the matter is that the article which was written by Kanchan Das was against the original scriptures. I have with me the original scripture where no such mandate was given. What was the mandate? That जैसे हम लोग बोलते हैं कि अपना सब कुछ ईश्वर को अर्पण कर दो, अपना सब कुछ अपने आराध्य को अर्पण कर दो. That thing was manipulated by Kanchan Das to write that you have to offer everything to the Maharaj. And I am just quoting this part of the article where he has written in Hindi. I don't know from where he found this Hindi, this Sanskrit version, and the translation is, I am reading this one paragraph and I quote, "Consequently, before he himself has enjoyed her, he should make over his own married wife to Maharaj, and he should also make over to him his sons and daughters. After having got married, he should, before having himself enjoyed his wife, make an offering of her to Maharaj, after which he should apply her to his own use." This Kanchan Das has written an article quoting that it is mentioned in our scriptures by Gokulnath Ji. Now I sat on conference with the important persons of Vallabhacharya Sampradaya. The original scripture was brought before me, and with lot of sense of responsibility, I want to say on this platform that no such Sanskrit version or English version is existing in the scripture. It was totally interpolated and manipulated. And kindly see the chain of events. When this article was challenged by Maharaj before the Honorable Supreme Court of Bombay, the Honorable Supreme Court of Bombay not just rejected his case, but went a step further, and they called our Srinath Ji as an Epicurean God, and many more such derogatory words which I cannot use here. The devotees were the devotees were called as devotees who are involved into all kind of sexual activities, adulterous activities. The entire Vallabhacharya sect was painted with the same brush. And now I have narrated before you two things: the article of Kanchan Das, the judgment of Supreme Court of Bombay in 1862. Now kindly see a step further. There was a book which was published by Saurabh Shah in Gujarat, in Gujarati language, and this is the cover page of the book. Srinath ji is shown, and it is shown as two people are having. So this is the cover page of the book. So, and now the next thing is now the fourth thing which comes is the movie Maharaj. Now if any one of you would have seen that movie, what is shown in that movie? Kanchan Das has been projected as a very revolutionary journalist. And it is shown in the movie that Kanchan Das was having a fiancée. That fiancée had offered Charan Seva to the Maharaj. That Charan Seva was seen by various other devotees through various jharokas after paying the gatekeepers. And the Maharaj was termed as a Maharaj who is misusing his powers and is abusing his own devotees. And Kanchan Das, as a very revolutionary journalist, wrote an article against this illegal practice, and he won before the Honorable Supreme Court of Bombay. Now the fact of the matter is, and it is written in the judgment itself, that Kanchan Das had no such fiancée. Kanchan Das had no such fiancée. So it's like you are making a movie on Bhagat Singh, you are making a movie of you are making a movie on Mahatma Gandhi, and your own imagination you are putting in this movie. So when this movie was challenged before the Honorable Gujarat High Court, the front line of defense was that we are protected because this is written in 1862 judgment. The front line of defense was that it is written in the book of Saurabh Shah. The front line of defense was that there is a article which has been published by Kanchan Das. This completely horrible and against the fact which goes to the root of the matter. This movie has been published, and when we are fighting on the lines of restoration of Sri Krishna Janmabhoomi, when we are fighting on the lines of restoration of Kashi Vishwanath, on Bhojshala, the fact is that there is need of the hour that we have to protect these sacred spaces to reclaim our gods. On the scriptures from the judgments of the court, if our gods have been called with various names, Lord Shri Krishna, who is also known as the God to do Dharma Sanstapna, if various terms have been used in the judgment against him, we all have to stand as a community to protect the dignity of our Ishwar, of our Aradhya. So this is a classic example. We all must read the judgment of 1862 by the Supreme Court of Bombay, and in this independent India, in this constitutional India, in this constitutional Bharat, we must challenge this judgment, and this judgment must be struck down at some day or the other. So as a community, as a civilization, we have to fight against the findings where the honorable judges, two honorable judges, have exceeded their zone of consideration. So this is the aspect so far as Maharaj movie is concerned. And I just want to spare 2-3 minutes on the recent burning issue of the Waqf Act 1995. Now we all know that the central government has brought certain amendments in the Waqf Act 1995, but I strongly believe that though these amendments are welcome amendments, they, so far as our demands are concerned, it fulfills 60% of our demands, but there are certain lacunas in this amendment, and the lacuna I want to just highlight in 2-3 minutes. And the first lacuna is that the lands which have been declared as Waqf property, there is no mechanism in this amendment to get those lands back. The inquiry which is going to be done by the collector, that is not a proper mechanism, because when we all know that various collectors under the various states are working under the dictates of the state government. So if we are looking at about the issue of Waqf Act, from a national perspective, a central inquiry commission has to be constituted so far as all the properties which are being declared as Waqf property, that has to be adjudicated by a special investigation team. This aspect is missing so far as this amendment is concerned. Apart from that, so far as section 8 is concerned, which is in complete violation of article 27 of the constitution, which gives a mandate that the survey of the Waqf, the taxpayers' money has to be used. The state government will spend the money so far as survey is concerned. That has not been amended in the Waqf Act 1995. So far as giving the status of public servant is concerned under section 101, that has not been amended. So far as the provisions of section 54 and 55 are concerned, which give the power to Waqf to remove the encroachment, that has not been amended. The Waqf tribunal under section 83 and 85 has not been amended. And there is no mechanism to get the properties which were evacuee properties under section 108, where the custodian was the central government, to bring back those properties. So far as this amendment is concerned, there are certain lacunas in this amendment. So as of now, the JPC is hearing this matter, and from this podium and this platform, I request all of you that we have to come together. And so far as this aspect is concerned, there is a section of the society who is completely against this amendment. So we as a civilization, as a society, must join hands. And so far as these suggestions are concerned, which I have highlighted in front of you, I am not saying these are comprehensive, but all of us must sit together, and our suggestions must also be brought before the JPC, and whatever we all must ask participation before the JPC, because this is a very, very crucial aspect. Waqf Act 1995 is going to be amended, and whatever our demands are, time is that we should ask for our demands to be incorporated in this amendment. I am so grateful and thankful to all of you for a very patient hearing. Thank you.